Hello friends, this is Dr. Shashi Agarwal. I welcome you all for the channel Shashi Agarwal Economics and Law Classes. Today our subject is business law and the topic is offer and acceptance. This is the second chapter. In this video we are going to focus on meaning of offer, what are the essentials of a valid offer, or we could say what are the rules regarding valid offer. If you find my video useful, please do like it, share it, and also subscribe my channel Shashi Agarwal Economics and Law Classes. So this is my app and is some app which you could download from Google Play Store. This app provides free study material and free mock test to the student of commerce, economics and management. It also provides structured courses like business law, principles of economics, business economics. So first of all, we will understand what is the meaning of contract. Contract is an agreement which is enforceable at law. The agreement which is legally enforceable, that is a contract. Agreement means one party makes an offer, the other party accepts it. Section 2E define an agreement, every promise and every set of promise forming the constitution for each other. Section 2B defines the proposal or offer which is made by the one party and the other party accepted, then it becomes the promise, or we could say it is the agreement. Agreement means offer and it should be accepted. The offer is given by the offerer and the offeree accept the offer. Offer is the starting point in the formation of a contract. Section 2A defines when one person signifies to another his willingness to do. Here, when one person makes an offer to other person, it means he expresses his willingness to do something. Like A told B, I want to sell my bike for rupees 50,000 to you. So here he's showing his willingness to do this act. He wanted to sell his bike or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence. Here one person signifies to another his willingness to do something or to abstain, like the creditor who wants to sue the debtor, but the debtor compromise and offer not to sue them. So that is the abstinence. When one person signifies to another his willingness to do or to abstain from doing anything, and the objective is to get the consent of the other party to such an act or abstinence. The person who makes the proposal is known as a proposer or the offerer. The person to whom the offer is made, that is called the offeree. Proposal is the expression of will or intention, where the intention is expressed. I want to sell my bike. This is the expression of will. A person making the proposal expresses that he is willing to contract on the terms which are mentioned, provided the other party to whom the offer is made will likewise express his assent to the same. Like A makes an offer to B, I want to sell my bike for rupees 50,000. B accept the offer without any condition. Then it becomes the agreement. For making the offer, there should be minimum two parties. One party cannot make the offer to himself. Section 2A shows the three essential elements: expression of willingness to do something or not to do something, or definitely the offer is made to other party, or intention is to get the consent of the other party to such act or abstinence. Every proposal must be communicated. If it is not communicated, then it is not a valid offer. And here, when the proposal is communicated to the offeree, so the intention should be to create the legal relation, and the offer should be definite and certain. It should not be vague. So it could be general offer, it could be specific offer, and there's difference between offer and invitation to offer and standing offer, which we will understand. So kinds of the offer, how made, it could be express or it could be implied. To whom made? It could be the general offer which is made to the public, specific offer which is made to the particular person. How an offer is made? It could be express, it could be implied. Express offer is one which is made by spoken words or in written form. Like A writes to B, I want to sell my bike for rupees 50,000. So here he is expressing his opinion in the written form. Or when A makes a verbal offer to B, I want to sell my bike. Here he is making an offer orally by speaking. Implied offer which is gathered from the conduct of the party or the circumstances of the case. Like a bus is going to Chandigarh and you sit in that bus. It means you have accepted the proposal. So here it is an implied offer. To whom an offer is made, it could be made to a particular person. If it is made to a particular person or particular group or body of person, then then it could be accepted by a particular person or particular group or body of person, not by others. When an offer is made to definite person, it is called specific offer. When an offer is made to word at large, it is called general offer. So it is a very famous case, Carlyle versus Carbolic Smoke Ball Company. A company advertised in many newspapers that a reward will be given to any person who contracted influenza after using the smoke balls according to the printed direction. Mrs. Carlyle used the smoke balls according to the given directions, but in spite of this, she had influenza and the company refused to give the reward. Then she sued the company and the court held it was general offer. By using the smoke ball, she had accepted the offer. An offer is different from invitation to offer. Invitation to offer, the purpose here is to circulate the information. There is an advertisement in a newspaper, even the goods they are displayed with the price tag at the shop, that is an invitation to offer, that is not an offer. Invitation to offer is a communication of information in the course of negotiation. A casual inquiry like I asked, what is the price of this chair? The person said it is 250. So it's a casual inquiry. It is not the offer made by the other person. A prospectus inviting the public to subscribe to the shares or debentures of the company. A catalogue of goods for sale is also an invitation to offer. Advertisement for the tender is also an invitation to offer. So offer is something different from invitation to offer. So what are the essentials of a valid offer? So one by one we are going to understand it. Offer must be made with the intention to create legal relation. If the offer is such where the intention of the party is not to create the legal relation, then it is not a valid offer. Like in the case of Balofar versus Balofar, Mr. Balofar was employed in Ceylon. His wife could not accompany due to the illness. And Mr. Balofar promised to his wife that he will pay certain amount every month, but he failed to pay. Wife sued the Balofar and the court held it was domestic agreement. Here the intention of the party was not to create legal relationship. So it is not a valid offer. Offer must be certain, it should not be definite, it should not be vague. Like in case of Taylor versus Purrington, Mr. A offered to take these house on rent for £85 provided the house is properly renovated, repaired and drawing room were decorated as present style. So it was vague. When you are making an offer, it should be certain, definite, it should not be unclear. Offer must be communicated to the offeree. If the offer is not communicated to the offeree, it is not a valid acceptance, it is not a valid offer. The offeree must be aware of the offer. Dalman Shukla versus Gauridat, like D's nephew was missing, he sent his servant P to find him. D announced reward for it. His servant found the nephew, but he was not aware the reward, so he demanded reward. His claim was rejected on the ground that he was not aware of the offer. When you are making an offer, it should be communicated, and the offeree should be aware of the offer. If he is not aware, then it is not a valid offer. An offer may be conditional. An offer can be made subject to condition. It can be accepted only subject to that condition, provided the condition they should be communicated when the offer is made. Like in the case of Thompson versus LM Railway, A was an uneducated person. He took an excursion ticket on the railway. On the ticket, it was written to see the condition on the back. One of the conditions was that railway company would not be liable for personal injury to the passenger. A was injured and he could not recover the damages. Offer should not contain the term the non-compliance of which would amount to acceptance. A makes an offer to B that he will sell his bike to him for rupees 30,000 and said that if I don't receive the reply next Monday, I will assume that you have accepted my offer. So it is not a valid offer. Offer must be made with a view to obtain the consent of the other party. Here we want to get the acceptance of the other party. If we want to, if we are making an offer in a funny way, like I'm offering my house for rupees 100, then my intention is not to obtain the consent of the other party. Lapse of an offer. An offer lapses. It means the offer can come to an end. Either the offerer or offeree dies before the acceptance. If it is not accepted within specified time or reasonable time period, then the offer comes to an end. What is reasonable? It depends upon the circumstances. 5 months has been held to be unreasonable delay in accepting an offer to buy shares in a company. If an offeree does not make a valid acceptance, an offer can also lapse by revocation. Like A makes an offer to B, but before acceptance, A withdraw his offer. So the offer will come to end in this way. Invitation to offer is not offer. Here the aim is to circulate the information. The goods are displayed in the shop with the price tag, that is invitation to offer. When a person makes an invitation to offer, the object is not to obtain the consent of the other person, just to circulate the information that he is willing to deal with anybody who on such information is willing to open the negotiation with him. Standing offer, where goods and services are required over a certain period. Firm may invite the tenderer as a standing offer, which is continuing offer. There is an offer for the continuous supply of certain article at certain rate over a definite period is called standing offer. Such offer, though accepted, do not give rise to contract. It, it is when the actual order is placed. Acceptance of standing offer has the effect that when goods or services are required, an order is placed with a person who submitted tender. Each time a different contract is made. Counter offer. It means the rejection of the original offer and making a new offer. In case of Hyde versus Ranch, a offer to sell his farm for rupees 1,000 pound. B said he will pay only 950 pound. So A rejected the offer of B. B next day offered 1,000 pound. A again refused. Then he went to the court, and the court said there is no contract. It is not a valid offer. So the legal effects of the counter offer, rejection of the original offer, and the original offer comes to an end. A counter offer results a new offer. Cross offer, when two parties makes identical offer to each other in ignorance of each other's offer. Two cross offer, they do not conclude a contract. They are not offer and acceptance of each other. D wrote to P on 28 November 71 offering to sell 800 tons of iron at 6,900 per ton. On the same day, P wrote to D offering to buy 800 ton at the rate of 6,900 per ton. So it is a cross offer. It is not a offer and acceptance. It is not a valid contract. A statement of price is also not a offer. Harvey versus Facey. Three telegrams they were exchanged between Harvey and Facey. Will you sell your bumper hall pen? Telegraph lowest price. Facey to Harvey, lowest price 900 pound. So the party said we agreed to buy bumper hall pen for 900 pound for the sum asked by you. So that is not a contract. That was just a casual inquiry. Many big organizations they have printed contracts. Such standardized contract often contain a large number of terms and conditions which excludes liability under the contract. The individual is bound to sign them. In recent times, the court have adopted various protective measures for the aggrieved party, excluding unreasonable terms. Special terms in a contract they should be communicated at the time when the offer is made. Where any special terms are to be included in a contract, they must be communicated to the offeree at the time when the offer is made. Olive versus Marlborough Court Limited, a hotel put a notice in a bedroom that owner is not liable for any loss of the client's goods. Notice was not effective because the special conditions they were not communicated at the time when the offer was made. So they were not communicated. So they are liable for the loss of the client's goods.